Welcome to the Business of NIL. My name is Ahmed, and today we have a very special guest, Mr. Mick Winter, who is a sports attorney, a leading college athlete, name, image and likeness lawyer, who has a very interesting background as he was once a Division I college basketball athlete. So Mick will be joining us, and what we'll be doing is basically breaking down the things to look for in NIL deals, contracts, what you should have in there, what you shouldn't have in them, so on and so on. So Mick will basically guide us through. And if you have any questions, just share them in the comments section. And just as I speak, Mick has joined us. Let me just add him on. Here we go. It's about to join us. Mick, how you doing?
Good. How's it going?
Very well, thank you, sir. How's things on your end?
They are going well. Yeah, weather's cooled down a little bit where I am, so things are going good.
Fantastic. Firstly, thank you very much for joining me on the show. It's an absolute pleasure to have you on.
Yeah, thanks.
My absolute pleasure. Let's start and get started with a bit about yourself and your background.
Sure. So I'm a former college athlete myself. I played Division I college basketball at the College of William & Mary, Williamsburg, Virginia. After that, I went to law school at the University of San Francisco, out in San Francisco, California. After that, I started practicing law in San Francisco at a pretty large law firm. And while I was there, I represented the ncaa in a few. I was out there in San Francisco for about 10 years, county law school. In 2011, I moved to Kansas City, which is where I live now, which is kind of close to where I grew up. When I moved to Kansas City, I worked for another big national law firm. Had some college athletics clients there as well, the Big 12 Conference, Conference USA. So represented them in all of their legal work there. And then about 2.5 years ago, I moved to my current firm, Kinney Hearns Perry, which is a smaller firm than the two previous firms I've worked at. And in terms of name, image, and likeness stuff, as a former college athlete who had worked a lot in the college sports law space, when name, image, and likeness, maybe a year and a half, 2 years ago, when it started to become, a thing that looked like it was going to start to happen, really started paying attention to, all the state laws that were coming out, what the ncaa was doing about the issue. So it was something that I was, very interested in personally as a former college athlete, and, thought it was something that athletes should have the right to do, to monetize their NILs. And then from the professional side, having the sports law background, it was something I was also very interested in professionally. And so, yes, sorry. And in terms of my my current NIL practice at Kinney Hearns Perry, my current firm, represents some universities, and I've also started representing some student athletes and businesses around NIL.
Awesome. Very decorated background or career, which could lead us into our next question. Basically, we're seeing a lot of movement in the world of college sport. We're seeing lots of deals being moved around at the moment. Student athletes, it's new to them. Obviously, this is all new. This is the first time in their history where they can monetize. So, from what you've seen, what advice can you give to student athletes to look out for in these deals? Let's say we have 3 or 4 tips, 5 tips, where you can share with us, like a list of things that they can take away every time they have a deal come to them. What should they look for?
Sure. I would say the first and probably most important thing is, what exactly are you giving? Let's say you're working with a business. What are you giving that business the right to do? Is it you're allowing them to use a specific picture? Are you allowing them to use your name or your face or a picture with respect to a specific product? Or are you just, does the agreement say you're giving them, carte blanche to take your picture or your face or whatever else they might use and use it on any product at any time in connection with anything they want to do? So I think that's, the first and most important step is what exactly are you this business right to do. Secondly, I would say how long is the term of any agreement you're entering into? Is it a one-time thing? Are they going to use your NIL in connection with one specific event, or is this going to be a deal where they can use your NIL for, let's say, a year or 6 months or multiple years? That's a very important thing as well. So what's the term of your agreement? Another very important item is, let's say you're doing a deal where there might be some intellectual property that is created. One example is a lot of athletes have been doing deals with t-shirt companies or other companies that, they're creating a logo that might go on a t-shirt, or maybe like a caricature of the athlete, kind of like a cartoon that's going to go on a t-shirt. Who owns that intellectual property? Does the company that's selling and designing the t-shirt, do they own that intellectual property, that logo or that caricature? Or is that some intellectual property that the athlete is going to own? So that's very important to have spelled out. Another thing that I think is very important is, what if the athlete or the business wants to terminate a deal they've already entered into? I think any agreement should have termination rights for both parties spelled out in an agreement. A pretty common way to deal with that is, either party can give 30 days notice that they want to get out of the deal. But not all agreements have that. A lot of agreements could have something that's a lot more punitive or harder to get out of the deal. So I think it's really important to look out for that as well. A few other important items is any deal you're entering into exclusive or is it non-exclusive? Say, let's go back to the t-shirt as an example. If you enter into an exclusive deal with a company for t-shirts, you can't work with any other companies that want to design and sell t-shirts that use your NIL. So that's another important thing to look out for. Obviously, non-exclusive is probably going to be better. But depending on what company you're working for, they might insist on something being exclusive. So that's another thing to look out for. And then a very important one, which is kind of the main issue surrounding NIL, is how and when are you going to get paid? Is it just a flat fee? Let's say for an appearance, are you going to get paid $500 for showing up at some event? Are you going to get paid up front? Are you going to get paid after the event? Going back to the t-shirt example, are you going to be paid royalties on each t-shirt that is sold? And is that going to be based off of gross profits or net profits? Because that can make a huge difference on the amount of money. Or are you going to be paid based off of some type of a commission? Let's say you do a sponsored post for a company and they have a way of tracking. Someone saw this post, they click on it, they click through to the company's website, and they buy a product. Are you going to get paid a commission based on that sale? So I think those are some of the really important issues. One more before I forget is, let's say you or the company you're working with, one of you thinks the other side has breached an agreement, done something you're not supposed to do, or you haven't done something that you were supposed to do. What happens then? Do you have the right to sue them? Do they have the right to sue you? Do you have to go to arbitration? Do you have to mediate it? There's a lot of different possibilities that can be spelled out in an agreement. and depending on where you're located and your situation, some might be better than others. What state law is going to govern any agreement that's breached. So there's a lot of considerations in these agreements, and obviously it's very important before an athlete enters into any agreement that either the athlete or whether if their parents are helping them out, if they've hired an attorney, if they have an agent, somebody needs to really read all these agreements very carefully, because you don't want to find yourself stuck with an agreement that's very one-sided and not in your favor.
Wow, there you go. A lot to take in. If you were to advise student athletes, actually not, we're not giving any advice. Let's talk in general terms here.
Yeah.
What should they not do? I mean, because everybody's telling them do this, do that, do this, do that. What should they not do?
Well, I think number one, you should not enter into a deal before you read it. Obviously, you should not enter into any deals without first notifying your compliance office about the opportunity you've been presented with. At a lot of schools, it's a violation of school policy, or even depending on what state you're in, a violation of state law to even enter into a deal before your school has been notified and given approval of the deal. And based on some of those policies, you could find yourself suspended from team activities if you enter into a deal before you've gotten permission from the school. So I think that's probably the most important. The two things I would say: really read a deal very thoroughly, you or someone that's representing you, and then number two, make sure you're disclosing that deal to your school before you enter into that deal.
What are your thoughts on the students who work with companies who get paid for, let's say, joining a platform? Then there's no clear distinction on what's monetized after that, all the data that's collected from the students. Do you have any thoughts around that?
Can you describe a little bit more what you're talking about? I'm not sure exactly what you're talking about.
So some platforms basically will say to you, come and use our platform and we'll pay you a certain fee, right?
Yep.
But the action that the student's doing doesn't really justify the money that's being paid, right? So, and then what you tend to find out is through different platforms is that data is then being sold, right? At a lot more than what the student's been paid for. So does that fall under any IP rights or any monetary gain that they can benefit from? Is there a way they can sort of stamp that out before that even happens?
Yeah, I don't think it really falls under any IP issue, but it's something that could be spelled out in any agreement. Let's say in the scenario you described, if a company is taking data that they gathered as a result of an athlete, getting people to that platform, and they make money off of that, the agreement could spell out how much an athlete is paid, sort of a commission or a royalty based on how much the company is making off of that data. So that's something that would just be addressed in the agreement. But it would have to be something that the athlete was aware of, or his or her representative was aware of as well, because a lot of people probably aren't even thinking of that. So that's a good point that you just brought up.
Absolutely. How do athletes avoid being sued?
Well, number one, whatever, if you do enter into a deal and it says you're supposed to do X, Y, and Z, then you should do X, Y, and Z. The main way that athletes are going to find themselves possibly getting sued would be to enter into a deal and then not do what they are supposed to do under the terms of that deal. So I would just say adhere to whatever that agreement that you signed says you're supposed to do.
Awesome. I think we'll definitely wrap it up. We've taken in a lot of the knowledge that you've shared with us, and we're extremely grateful. and appreciative of your time. Before we let you go, do you have any parting words?
I would just say that it's obviously really exciting for athletes to have, this new opportunity to monetize their NILs. It's something I wish that I had the opportunity to do back when I was in school. But at the same time, although it is very exciting, you need to, be careful about people you're entering into deals with. There are definitely some bad actors out there trying to take advantage of athletes. So be careful who you're entering into deals with. And then, when you do find a deal that you want to enter into, make sure you're reading any agreements you enter into very carefully. Spend time going over it with someone else. Make sure you're disclosing all your deals to your school. That's a very important part of it as well.
Absolutely. Ladies and gentlemen, Mick Winter, thank you very much for joining me on the Business of NIL. Thank you.
Thanks for having me on. Appreciate it.
My pleasure.